Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering college panics as $15 million awarded for false claim of sexual assault. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from the College Fix, Philadelphia University ordered to pay $15 million to doctor for anti-male bias in Title IX case. Male doctor and female subordinate each opened Title IX investigations, but they only pursued the female's investigation. And so, a Philadelphia university must pay $15 million to a male doctor after a jury found it had discriminated against him based on gender in a Title IX investigation. A December 11, 2023 jury entered the judgment against Thomas Jefferson University based on its decision in favor of the plaintiff, former Rothman Orthopedic Institute surgeon John Abram. One of his subordinates, medical resident Jessica Phillips, had accused him of sexual assault. Irene Riaz, senior director of news and media relations at Thomas Jefferson University, told the College Fix that the school is disappointed in the jury's verdict and continued to believe Jefferson treated both parties fairly and equitably in this matter between a faculty member and a resident physician learner. Nevertheless, we respect the jury process and thank the jurors for their service, Riaz said. Jefferson will consider all appellate options available to it. Campus due process commentators spoke with the College Fix on why the jury might have determined Jefferson violated Title IX and on the implications for other universities. Edward Bartlett, president of the policy organization Stop Abusive and Violent Environments, also known as SAVE, pointed to the disparity between the university's investigation of Dr. Abraham's original Title IX complaint alleging sexual misconduct on Phillips' part, the student, and Phillips' own subsequent Title IX complaint involving Abraham. SAVE seeks to assure that the federal Title IX law is applied consistently and fairly to all students, both male and female, according to its website. Abraham had reported to the university in June 2018 that Phillips committed sexual misconduct by getting him drunk and coercing him into intercourse at a party at his house. Subsequently, Phillips submitted her own Title IX complaint in which she accused Abraham of sexual assault. The university had properly pursued Phillips' case, but not Abraham's, according to Bartlett. When there is a series of untoward actions, such as the university's total failure to pursue Abraham's case in light of this discrepancy, it is reasonable to conclude it was due to sex bias. Bartlett said the best way for the universities to assist the accused parties in Title IX cases would be for them to follow their own rules and ensure the accused receives due process procedures, beginning with the presumption of innocence. On June 19, 2020, Abraham, who held clinical privileges and a faculty appointment at Thomas Jefferson University Hospital, filed a civil complaint against the university, accusing it of violating Title IX as well as breach of contract, intentional infliction of emotional distress, negligent infliction of emotional distress, and torturous interference by defendants with plaintiff's business relations with Rothman Orthopedics. The civil case went to trial this year. After 4 days on December 7th, the jurors concluded Thomas Jefferson University had discriminated against Abraham as a male and intentionally interfered with his ability to earn money as a Rothman surgeon and partner. The case covered the competing Title IX complaints, with Abraham's side arguing that his own investigation was mishandled. The Inquirer reported Phillips wrote that, quote, she woke up in Abraham's bed the morning after the party naked, disoriented, and covered in bruises. Quote, she said Abraham sexually assaulted her and filed a criminal complaint against him in early July 2018, according to the paper. Montgomery County prosecutors closed their investigation with no charges about 4 months later. Days after the party, Rothman Orthopedic Institute suspended Abraham, and Thomas Jefferson University forced him to take a leave of absence, according to the Inquirer. Rothman is academically and financially linked to Jefferson. Abraham told jurors he resigned from Jefferson in December 2018 because university leaders told him he would be found culpable at Phillips' Title IX hearing. Rothman fired him last year for allegedly failing to bring in enough revenue as is required of the firm's partners. Abraham originally sought $5 million from Jefferson in compensatory damages and additional punitive damages, arguing the university should be punished for acting unlawfully. Legal scholar Eugene Volokh, a visiting fellow at the Hoover Institution, told the College Fix that successful Title IX lawsuits based on claims of sexual misconduct are unusual, particularly in combination with such a large payout. $15 million is a lot of money, Volokh said. A lot of people perceive our legal system as providing massive verdicts, but that's actually quite rare. While the large amount may be due in part to Abraham's earning power as a doctor, it also suggests the jury is pretty upset, Volokh said. The jury must have thought that he really was treated worse because he was a man. He also said that the verdict would, quote, send a signal to university administrators. Administrators might say, wait a minute, if it happened at Thompson Jefferson University, it might happen to us. While it might be the case that universities become too cautious, the case is a reminder to universities that they need to be careful here with regard to sex discrimination against men as well as against women, he said. Abraham's complaint accused the university of inactions on his own Title IX case and engaging in substantial errors in violation of federal law, state law, and defendants' own policies. These allegations included, quote, failing to investigate Dr. Abraham's allegation that Roe had engaged in non-consensual sexual intercourse with him, and concluding Roe's investigation without allowing Dr. Abraham a full and fair opportunity to provide a statement to present over 29 material witnesses along with witness statements and to offer other evidence on his behalf, according to the complaint. When they say Roe, they're talking about Phillips, the woman involved in the situation. Even more, quote, during the period in question, Dr. Abraham's superiors made gender-biased statements towards him, the complaint states. By way of example, University Administrator Dr. Alex Vaccaro told Dr. Abraham that a man cannot be sexually assaulted by a woman and discouraged Dr. Abraham from making any such claim. In a September 10, 2021 memorandum regarding a motion by Thomas Jefferson University to dismiss the case, U.S. District Court Judge Michael Bailson wrote that the university conducted a superficial, flawed, and gender-based investigation into Doe's allegations against Abraham. Again, Doe is like Jane Doe, making reference to Phillips, the woman making the accusations. Also from the College Fix, this is a defamation suit that a student actually was able to win. From the College Fix, former Clemson student wins $5.3 million in sexual assault defamation lawsuit. A former Clemson University student has been awarded $5.3 million by a South Carolina jury as a result of his lawsuit against his accuser and others. Quote, last week, a South Carolina jury awarded $5.3 million to a wrongfully accused Clemson University student on defamation and civil conspiracy claims. SAVE, a due process advocacy group, announced in a news release yesterday. The decision is believed to represent the largest amount ever awarded to a student falsely accused of sexual misconduct. The defamation and civil conspiracy claims arose from a consensual sexual encounter between two Clemson University students, plaintiff Andrew Pampu and defendant Aaron Wingo, in October 2015. Attorney Kimberly Lau wrote in a Substack entry. Lau represented Pampu. She did not provide any official documents from the settlement in her article. Quote, Ms. Wingo falsely characterized the sexual encounter as a sexual assault due to her alleged alcohol-induced incapacitation. However, the evidence showed that Ms. Wingo was not incapacitated at the time of the encounter, nor did she forget the incident. Lau previously helped Pampu settle with Clemson. The attorney finalized plaintiff's settlement with Clemson University to resolve plaintiff's claims against the university for violations of Title IX and the Education Amendment of 1972 and the 14th Amendment of the Due Process Clause, she wrote. The university was required to remove the disciplinary motion from plaintiff's transcript and make a monetary payment to plaintiff for his damages. Pampu told the Daily Wire he hopes other men in this situation will be inspired by his victory. Quote, when I received the verdict, I was overwhelmed with emotion and incredibly relieved. For 7 long years, I carried a burden of accountability that was not mine to bear. Consequently, my family battled through the process with me every step of the way. He continued, by the grace of God and with the support of my loving family and counsel, I was somehow able to persevere throughout the adversity and fight for the truth. I feel incredibly thankful for all members of the jury in Pickens, South Carolina, who chose to end this nightmare for me. Quote, I hope that the favorable verdict gives hope to many other young men who are in a position similar to mine, Pampu said. There's a lot more to that story, and we'll do another video on it. Also from the College Fix, Washington Supreme Court ruling may strengthen due process for students. A recent Washington Supreme Court ruling regarding sexual assault has 2 legal groups hopeful for the future of students' due process rights. In its ruling, the state's highest court held that universities do not have a duty to provide reasonable care to protect students from foreseeable harm caused by other students off campus. The case involved a female student who accused Washington State University of negligence after a male student with a previous record of sexual misconduct assaulted her off campus. While the ruling on the surface is about the scope of the duty of care Washington State universities have towards their students, two higher education legal organizations see it as a potentially wider victory for the due process rights of all students. Quote, the court recognized the wisdom of limiting the reach of public colleges into the off-campus lives of its students. We should not want educational institutions policing the lives of students 24 hours a day and across the globe, according to the Foundation for Individual Rights and Expression. The justice's decision noted that Washington State has a special relationship with and duty towards its students, but determined that its duty is limited to where a student is on campus for student-related purposes or participating in a school activity. They reasoned that the university's duty could not extend to off-campus activities because, quote, a university simply has no power to dictate students' movements off campus and away from the oversight of campus security and administration. Edward Bartlett, the president of SAFE, an organization that works to assure fairness and due process in schools, told the College Fix that limiting the scope of universities' involvement in such allegations is a good thing. Quote, there's a growing awareness that campus disciplinary committees are failing to observe the most basic notions of fairness and due process, Bartlett said. Just recently, a jury in Philadelphia awarded a $15 million decision against Thomas Jefferson University for failing to investigate the claims of a falsely accused faculty member. Instead of relying on an expanded university scope of duty, Bartlett said, every jurisdiction in this country has a law enforcement system that seeks to strike the right balance to protect the interests of both the accuser and the accused. Allegations that fall outside the jurisdiction of the university should be referred to local law enforcement authorities for investigation. Bartlett said because the university disciplinary process is so flawed, persons who believe in due process should oppose any attempt to expand the scope of Title IX offices to off-campus activities that are not directly supervised by the school. The organization FIRE made a similar point, telling the College Fix there are significant limitations to a university's authority when it comes to policing off-campus allegations of sexual misconduct, and such matters are better left to the criminal justice system. Sexual assault is incredibly serious, and any institutions involved with reviewing complaints of inappropriate behavior of any kind need to give every side full due process and treat everyone the same regardless of their race or their gender or their sexual preferences. There should be no discrimination. Everyone should get a full evaluation and be treated fairly. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up, and I'll see you again soon with another video. And if I don't see you, I will miss you.